Welcome back for our 4:15 p.m. panel, Insider Trading 360, Enforcement Trends, Key Cases, and Prosecutions. Our moderator for this panel is Bridget Moore. Bridget is a partner at Baker Botts in D.C. She is chair of the firm's litigation department and a member of the firm's executive committee. Before joining Baker Botts, Bridget served in the Division of Enforcement at the SEC, where she conducted investigations involving the anti-fraud provisions of the federal securities laws, proxy violations, insider trading, and various disclosure and reporting violations. Next to Bridget is Jonathan Barr, who is a partner at BakerHostetler in D.C. John has more than 25 years of experience in government investigations, including representing clients in numerous investigations involving insider trading allegations. In addition to experience in private practice, John is a former AUSA, DOJ fraud section trial attorney, and SEC senior counsel. Next to John is Luke Cadigan, who is a partner at Cooley, where he is head of business litigation for the U.S. East Coast and partner in charge of the Boston office. Luke is a former assistant director in the enforcement division of the SEC, serving in the Boston regional office and in the SEC's FCPA unit. Luke also served as SEC senior trial counsel. Next to Luke is Stephen Crimmins, who is a partner at Davis Wright Tremaine in D.C. Steve defends enforcement matters involving the Securities and Exchange Commission and other financial regulators. Steve spent 14 years at the SEC, where he co-managed the Enforcement Division's trial unit in prosecuting jury and non-jury securities cases in federal courts around the country and administrative proceedings. And at the end is Dan Hawke, who is a partner at Arnold and Porter in D.C., where he practices in the Securities Enforcement and Litigation Group. Before joining the firm, Dan spent 16 years in the SEC's Division of Enforcement, where he served as the first chief of the Division of Enforcement's Market Abuse Unit. Dan also served as director of the SEC's Philadelphia Regional Office for 8 years. And with that, Bridget, I'll hand it over to you.
Great, thank you so much. Thanks everybody for joining us today. We're obviously going to cover a lot of topics on insider trading, what the commission is focused on, and kind of the hotter topics. And so we're going to start there. And certainly while we're still seeing the more traditional insider trading cases, one of the more popular issues that has emerged is shadow trading. So I'm going to kick it to Steve, and he's going to set the table for us on SEC v. Panawat, remind us what that theory of liability was there, and we'll go from there.
Thanks, Bridget. I think everybody in the room knows the basic facts of Panawat. Poor Matt Panawat got out of bed one morning and I think it was 2015 or 16, and little did he imagine that a decade later almost we'd be talking about him, and probably will for a few more years, poor guy. But he worked for a company called Medivation, mid-cap biopharma company. They were being pursued by a giant, Sanofi. They didn't much like what they were hearing. It looked like the effort might turn hostile. They brought in J.P. Morgan, Evercore to look for alternatives. Panawat was a senior guy at the company. He was vice president of business development, one of the top executives in the company, and he got assigned to work on that team. He worked closely with the investment bankers. They looked at a number of options. Among their efforts, they decided to line up what would be the peer companies of Medivation. And there were about 7 or 8 of them that they just studied to be informed. One of them was a company called Insight, another mid-cap biopharma oncology-focused company. It was there. So after a couple of weeks doing that, Panawat, with a couple of other very top executives, heard from their CEO, happy news that another giant had come along, Pfizer, and was going to make a very sweet offer, much to Medivation's liking. Pfizer wanted to move really quickly. It was then Thursday. Pfizer wanted an agreement signed on Saturday. They wanted to announce it on Monday morning. Great news, confidential. So Matt Panawat goes to his computer. 7 minutes later, gets on his own brokerage account and starts buying short-term, out-of-the-money call options. Okay, right away you think, oh my God. So were they in Medivation? No, as everybody in the room knows, no, they were in one of the other peer companies, Insight. He obviously thought he was okay. He was doing it in his own account. He was doing it from his office computer. He was buying a large volume. I mean, he couldn't have been more conspicuous. But, you know, and now we have the case. So what happened? What happened was that obviously the deal went forward with Pfizer. It was announced. All of the peer companies, 7 or 8 of them went up. Not as much, of course, as Medivation, which went up a gargantuan amount, but they all went up about 8% or so. And with leveraged investment, Panuot made some money. He invested. His profits were, I think, $170,000. So far, so good, because he didn't buy Medivation. He bought one of the other companies. No, he got sued by the SEC, as everybody in the room knows. His counsel, a very good counsel at Cadigan, moved to dismiss. The judge in San Francisco, Judge Hawke, said, no, I'm not going to dismiss it. They stayed a claim. Discovery proceeded, moved for summary judgment. No fact issues are present. You're going to go to trial. They go to trial, and there's a jury verdict in the SEC's favor this year in April. Yikes. So Panuot's counsel does the usual. They move for a new trial, then new trial or alternatively judgment as a matter of law. Judge Orrick decided it just 2 months ago in September, and he denied it. There will be an appeal, and these are really the two issues, I think, for us to think about at this point in the lengthy lifespan of the Panuot case, which is definitive of insider trading. It will be a major turning point in insider trading law in United States law, and it will go up on appeal. And one has to do with the scope of the misappropriation doctrine. It had to be charged, obviously, as misappropriation. Panuot did not buy Medivation stock, which would be a classical theory case as an insider. He bought another company's stock, so he was under the misappropriation document, misappropriating the information to trade another company's stock. But what was different was it exploded the concept of scope, which is packaged as materiality under the securities laws when you talk about a misappropriation case. Okay, was the information taken from the source of the information? Was it taken to invest in something where that information would be material to what you invested in? Was that going to be material to Insight? Well, the SEC's take on it originally was, well, yeah, because there was a limited group of peer companies. There were only 7 or 8 of them. And he knew, he had obviously inside information. He knew Pfizer was going to make an offering, price point, all kinds of good stuff. But it was a limited set of targets, not targets, but a limited set of companies to invest in. That was stretching it pretty far. But as the litigation proceeded, both under the SEC's arguments and certainly what the judge decided 2 months ago in September, it got exploded beyond belief. It's, well, if you misappropriate information from a source where you owe a duty, your employer, and you use it to trade any securities at all, totally uncabined, you've got a problem. And that's taking misappropriation to a whole new level. You'll recall misappropriation originated in the 80s and the early 90s when you had this problem that in a takeover situation, if you work for the target, you have the classical theory nice and crisp and clear. But what happens if your company, your employer is the acquirer, and you buy the other company? You have to have a misappropriation doctrine to cover that. And we sort of sweated during the late 80s and the early 90s whether the Supreme Court would buy it. The appeals court started to buy it. The Supreme Court, of course, bought it in O'Hagan in 1997. But it was just for the other company in an acquisition. It was very cabined. And okay, maybe you could stretch it to 7 or 8, but to stretch it that you take information and use it to buy everything. We heard in an earlier panel today, what do you do if you work in the asset management area, where you're always looking at companies and seeing how action in one company will affect another. What do you do if you work for an economics firm and you get information, macroeconomic information, and you use it to make a purchase? What do you do if you work for a political consulting company and you get some information and you use it to make a targeted purchase? I mean, you can think of all kinds of crazy examples. What do you do if you invest in this sector? Warren Buffett, Peter Lynch, a lot of other greats said, why would you know? And a lot of executives, I think, do buy in the sector where they work, just the sector, because they're very familiar with how the sector is doing. What about them? They always have information about their own companies, and they buy in the sector. Are they going to be stuck? This is not the misappropriation doctrine that the Supreme Court endorsed in 1997. It's not the misappropriation doctrine as it was understood during the 2000s, and I would suggest the 2010s and beyond. This is new. This is different. This is totally uncabined, and people don't know what to do, especially individual investors who don't have lawyers at their elbow and have to figure this stuff out. How are they supposed to do? This is fair notice, obviously, due process. So I think it's aching for guidance from the appeals courts, and it's aching for the Supreme Court to revisit O'Hagan, and this is a great vehicle for it. I'm sure Skadden will at least have some interest and talk to their client about taking it up to the Ninth Circuit, and hopefully the Supremes will take it beyond. On that point, I think the other thing to think about, and then I'll stop talking, is do you really have a breach here? Did he really misappropriate information? Well, for the first minute I was talking, it sure sounded that way. But think about it for a second. And we only found out, we really got into the plumbing of the case with the judge's order in September. We found out all kinds of stuff we didn't know previously. For example, the CEO of Medivation was standing by to testify at trial that Panuot's purchase of Insight in no way violated Medivation's insider trading policy, and that Medivation had no problem with it at all. Likewise, the Vice President of Finance was standing by to testify at trial exactly the same, only as recounted in the opinion, he was going to add a couple of adverbs to it, like absolutely not a problem, and a few other things. He seemed more enthusiastic about it. The judge excluded it. How could it be excluded? I mean, it's certainly, if the CEO and the Vice President of Finance didn't think it was a problem, how is Panuot supposed to think it was a problem? Didn't that go to Siena? That's the obvious part of it. But then when we look at misappropriation as a doctrine, we all know with classical that if you do relevant disclosure to the market, then you can actually trade, although that's usually impossible to do, so you have to abstain from trading. We also know that in the misappropriation cases, you make disclosure to the source of your information and say, I'm about to trade on this information, have you got a problem with it? Well, he didn't formally take the step and go to knock on the door of the CEO's office, but the CEO said, my answer would have been yes, it was of course permitted, and the Vice President of Finance would have said, absolutely so. They're the ones who effectively, CEO is the one who gave them the information. How could that be a breach of duty? And I think that again gets into, wholly beyond the scienter argument that Panuot has, it gets into the guts of what is misappropriation, the duty element of misappropriation. That's a separate and distinct appeal point that I think the Supreme Court, certainly the Ninth Circuit, and I would hope the Supreme Court beyond that, has to figure out. In terms of setting the table, I'm way overdoing my time, but one last point I'll leave you with, which is on remedy. That was kind of curious. SEC did not ask for disgorgement. They filed the case fairly early on in 2021, and having filed it then, it was close on the heels of Liu. And Liu, as we all know, with disgorgement, really caused a lot of confusion, probably good, if you're on the defense side, a lot of good confusion, on equitable principles and how they all play out. Shortly after that, Congress got into the act with something with a great name, the National Defense Appropriations Act, in January 2021, which had this slapped at the tail end of it, where they added disgorgement provisions to the Exchange Act, which we now know is an amendment to 21D3 and creation of 21D7. So there was all this stuff stewing as to whether there was harm to investors, whether the money could be refunded to investors. So In that stew, the SEC chose not to ask for disgorgement. They, of course, got a 10B injunction from the judge. But the other things get interesting, penalty and O&D bar. The judge said, this situation is a very serious violation, very serious. And as a result, the penalty should be a 3-time penalty. And you recall insider trading, the penalty calculation is a little different as a result of the Insider Trading Sanctions Act of '84, which amended 21, was it Cap A of the Exchange Act to provide for tiering of one-time penalty, which you usually get, 2-time penalty if they're really angry with you, and a 3-time penalty, which you never see. Well, the judge hit poor Panuit with a 3-time penalty. All these mitigating circumstances, a 3-time penalty, profits were $107,000. He got hit with a penalty of $320,000 or so. Very serious. Then the other thing, the last point to make is the other element of relief the SEC asked for, not unusual, was an O&D bar. So he reverted happily to the Patel standard, SEC v. Patel of the Second Circuit, you remember in 1995, which set out a framework of it's kind of like the framework for injunctions, but the judge adhered closely to that, and it's good to see that still being followed by way of discipline. And he said, it's not an egregious case, and he didn't want to his credit, I don't want to ruin Panuit's career. Panuit is an officer of a public company today, as reported in the opinion. Didn't name it, of course. So he said it's very serious, so a 3-time penalty, but not egregious, so no O&D bar. So again, I think Judge Orrick's trying to get it right, to his credit, probably, I'm sure, a very decent person, but confusion over how you apply remedies in SEC cases and insider trading in particular. So a lot of unusual stuff in the case. That's this installment, and colleagues will talk about it in a second, but it's going up. It's going to the Ninth Circuit. It's going beyond. It's very fundamental to what a misappropriation case is arisen in this wild and evolving area that we know as insider trading law. Consequences, I'll throw it out to my colleagues here on the panel. What does this mean for people who want to get engaged in sector trading? What does this mean for public companies that are trying to do and revise their insider trading policies? What does this mean for people trying to do good training programs for their employees and show that they're doing the right thing? I don't know. Who wants to pick it up?
Can I just ask you to address the principal and agency argument that was addressed in the panel opinion?
Yeah, it had to do with basically the agency part of it was what your duty was, whether it had to do basically with
The employment relationship.
Yeah, no, it had to do with the policy. And he said, and it was kind of an interesting argument, and that's a good point to make, that he said you can have a duty imposed on you by agreement under the insider trading policy, and that's by contract, that's by agreement, that's the legal duty. But he said, look, we don't really have to wring our hands about that, because if you're entrusted, his word, and the right word to use, entrusted with confidential information, as Dan says, it's an agency concept, an agency law, understanding of the law, and it's an agency principle, but still to create a duty. So duty, for purposes of insider trading and misappropriation in particular, whereas, as Dan points out, can be created expressly by agreement, by contract, and also can be created under agency principles. Again, making it, I would suggest, further mushy. Insider traders are individuals. They're retail investors. Most of them are pretty unsophisticated. Panuit, again, I'll say, was using his office computer and using his own accounts, buying a conspicuous amount of options days before the announcement with precise timing. I mean, he wasn't trying to hide anything. I'm sure thought he was okay. He was acting in the spur of the moment. We would say imprudently. We would say he should have thought, obviously, but we're lawyers. He wasn't a lawyer. So again, It's a mush, and it needs to get straightened out. Insider trading law started out with some very, very basic core principles about fairness and justice and duty to your investors and stuff like that, from matter of Katie Roberts in 1961 that kicked it all off, through Texas Gulf Sulfur, the next case in 1968, and then suddenly when we actually started getting insider trading cases in the 80s, real insider, well, the 70s too, 70s and 80s. I mean, it was all about respecting your duty to your shareholders, respecting your duty as maybe a senior officer, director, whatever you were. Now, it's got to be sport fishing. It's fun for us to speak about. We love speaking about it. It's great to talk about when you teach a law school class or have a program like this. But gosh, for lawyers who counsel clients, it's interesting. It's wonderful. But what about those individuals like Matt Panuot 10 years ago, or almost 10 years ago? So anyway, that's part of the mush. But anyway, Dan raises a good question. What do we do about this going forward?
I thought one thing that was really interesting was the SEC's position on this, and this was from the director, and their litigating position was, there is nothing novel about this case. This is just a normal insider trading case. It meets the elements, nothing novel. And Panuot was like, what are you talking about? This is completely novel. I had no idea that I could be prosecuted for insider trading, for trading in the stock of another company where, in his mind at least, the information had nothing to do with the other company. The other company wasn't involved in the transaction. It wasn't a competitor to his company. And so he wanted to make part of his defense, look, from a scienter basis, I never intended to violate the law because I had no idea this was insider trading. And the commission was able to persuade the judge that it was not indeed a novel insider trading case. And the judge limited Panuot and didn't allow him to make those arguments in his defense. And I suspect that's why these people that he had lined up to say, hey, it wouldn't be a problem.
He was allowed to say that Panuot, he's allowed to testify that Panuot had never heard of the SEC ever doing a case like this, but he was not allowed, and his lawyers in argument were not allowed to say, this is a new theory, it has never been done before, which of course was true. But he was only allowed to say, I, Panuot, have never heard of people being sued by this before. And also, I think, what was he allowed? The vice president of finance was allowed to say that he saw nothing improper about one of his employees trading in biopharma stocks generally. But then he was cut off. He was not allowed to say, we had no problem with this providing insight, and nor was the CEO allowed to trade it. It was a hybrid, but I think it's going to get reversed.
I think what really crushed him, a couple things, and what made the judge unsympathetic to his arguments were, one, he traded with the information within 7 minutes of receiving the information. He bought out-of-the-money call options, and he bought, I think, half of his salary, an amount of half of his salary in these out-of-the-money call options. And I think when you see facts like that, they seem to suggest so strongly a belief that this is really material to this investment. I think that really hurt him. And then when he testified, he testified that he wouldn't, that the fact of that information coming wouldn't have changed the timing. The timing of his trades, and I don't think the jury believed it. They were only out a little over 2 hours, and they convicted him.
Yeah. So, I think while good advocacy on one side of the fence or the other can persuade a jury, and it depends on who you get on the jury, obviously, too, but why should the individual like Panuot, who obviously wasn't trying to hide his trade, why should he have to figure this out? Why should he get surprised by this? So I think that's why
I would say this: the SEC will argue every time, and we've been defending these cases forever. People use their own cell phones. People use their own computers. That happens all the time.
What's interesting to me is how, when you talk about sector trading, or you talk about industry trading, it raises questions about sort of materiality, how do stocks really move in tandem or in sympathy with one another, and what are I've seen, there's an interesting article written by Professor Verrett at George Mason that talks about market connection, and establishing market connection between the company that you trade in versus the company that's subject to the news, and whether or not there is a correlation or a variance between how the stock moves in sympathy with the underlying news.
Yeah,
What does that do to a company that's got to put together a restricted trading list?
Well, I actually think that one of the things that I see quite a bit is insider trading policies that are ambiguous, well, twofold, ambiguous as to whether or not they create a duty. So the first question I usually ask when I'm looking at a policy is, does the policy establish a duty of confidentiality? Even if there are other confidentiality provisions that the company relies on to impose that duty on employees, is there a duty in the policy? And then does it address trading in other securities, trading outside of the securities that are involving the company or its partners or targets? And so to me, trying to educate, part of it is educating clients about how sector trading works and what happens when you trade, that you can trade in a stock that will potentially benefit from the news affecting another stock. But you can imagine all the potential arguments that come into play as to both scienter and materiality, breach of duty, and the foreseeability of you know, can anyone say that, you know, I mean, there's even a question in connection with material information is how much is the stock going to move? It's one thing to ask that about the company that is the subject of the news. It's another thing to ask that about a company that's maybe not the subject of the news, but just happens to be in the same sector.
I think that's a great segue. You know, this idea of this appeal will be very interesting, certainly, but you know, this concept is out there, and companies, officers, directors are going to have to deal with it. And you know, the conversation around what do your policies and procedures look like, you know, how to best protect the officers, directors, the company. And we've recently seen, and I'm going to kick it over to Luke, a sweep out of the asset management group in the Boston office of the SEC that is titled MNPI, in the matter of certain MNPI policies and procedures, that at least seems to suggest that the SEC is trying to get their arms around what policies may look like in this area. Can you give us a little more background on what you know on that?
Yeah, and I think this is a sweep that really hasn't gotten a lot of attention, but it's, again, as you mentioned, a sweep out of the asset management unit in Boston. And at least our clients in it are registered investment advisors with a sector focus, in the case of our clients, the life sciences space. But and it's focused on policies and procedures to prevent the misuse of MNPI under 204 Cap A. And perhaps that's not surprising. I mean, the exam risk alert went out a couple years ago highlighting deficiencies, particularly with respect to alternative data, value add, investors, expert networks, et cetera. And for those who are here this morning, the asset management panel talked about the Sound Point and Marathon cases, you know, which talked about how you deal with information from investors committees. But that was not the focus of this week. And the staff in Boston has been transparent about its focus and said very directly that it is interested in how firms, particularly sector-focused firms, and given their sector focus, handle what it calls adjacent MNPI. In other words, MNPI that affects other companies in the same sector. And it's looking for, in particular, information gained through NDAs, through pipes, through board seats, through creditor committees, and I'm trying to understand what the firms are doing about setting up protections to make sure that they are preventing shadow trading. So, while Steve mentioned, you know, the various issues with Panawat, it's clear the firm is not only, building on Panawat with respect to insider trading, but it's taking it even further and claiming that companies have a duty under 204A to be preventing shadow trading. And, I think that we've seen some of this, and many of you may have been involved in some of these investigations, but on the company side, I know that a few years back, we were getting investigations where it was clear the staff was focused on whether a particular VC firm in the life science space was using the information it gained through its access as an investor to trade on other companies in the life science space. I never saw anything that came of that, but you could tell that was where the SEC was particularly interested. And so now you have this sweep, and frankly, again, I don't think it's gotten a lot of attention, but it's going to really cause us to have to really, as Dan had said, educate our clients, particularly the regulated clients, the investment advisors, on what they're doing to ensure that the information they gain through NDAs, pipes, board seats, et cetera, creditors committees, what they're doing to make sure that they're not using that information to trade on other securities in the same sector.
And Luke, is there any kind of paradigm or model? I mean, as we were speaking about with Panuet, it's such a mushy articulation and extension of the misappropriation doctrine. And now it's being rolled out exponentially, potentially, into advisors in sweep-like fashion. So to deal with that, training, of course, and alerting clients to it is one thing, but as you say, there has to be something put in place by way of policies and procedures. How do you manage and cordon and ride herd over something that's inherently that mushy? Does it have people are beginning to ask the question, but are we going to see answers soon, or what?
No, I don't think so. Indeed. I
Is
can
there
tell
an
you
answer?
this. I think the thing that really shocked me by this is you would think that there would have been a risk alert, some sort of guidance or something that came before this, and it doesn't seem like there are a lot of firms that are in this sweep. sometimes you throw out a broad sweep and you find the most egregious actors and you make that the basis for that. But in particular, it's going to get very mushy. And again, to the point that you and Dan raised, John May raised, how are you really going to know the impact of the information you gain on a particular company on others in that same sector unless you restrict all the other securities in that sector?
I love it. For a non-novel case, for a case that's not novel, we now have a new term, adjacent MNPI.
Yes, I'm glad you hadn't heard that either. I hadn't been aware of that one either.
It is a challenge for regulated entities that are required to create and design and create policies to reasonably protect material non-public information. Because now we have to deal with adjacent MNPI.
And it's not just raising a question or an examination issue. This is an enforcement sweep. So we know that the staff is really, really unhappy. We got that part, but we'd like to know an answer or a suggestion from them, as Luke, as you say, some sort of guidance or alert or something as to what they expect.
Yeah, well, the big thing here is the concern that others raised today, and again was sort of answered with Soundpoint and Marathon, is whether staff is going to pursue these cases, even though there hasn't been any apparent insider trading, and clearly they have been. And you wonder whether or not the new administration, is going to have the same feeling on these types of things where there hasn't actually been a violation.
Yeah, I wanted to kick that question to Dan, so thanks for raising it. We've kind of seen this movie before in terms of sweeps going out and then settlements that go to not an underlying violation, but a control violation. It seems like the panel thinks that we'll start potentially to see those cases here. What do you think, Dan?
So I think that that when you look at off-channel comms, and there's a lot of misunderstanding in terms of why the SEC cares so much about off-channel communications, and it's in the insider trading space that those communications are especially important, right? Because if somebody's using their cell phone to tip or to trade or to coordinate a meeting or information flow, then the argument is that the only way, if it's a regulated entity like a broker-dealer or an advisor, the only way the SEC can get that information is to go to the individual directly. between off-channel comms, record keeping, and then whether it's 15G controls for a broker-dealer or 204A controls for an advisor, you have a situation where there's a heavy enforcement focus on controls and record keeping and process, that it's not, and it's all ties back to the division's ability to investigate these cases. The thing that concerns me, and when you talk about the Marathon case or the Sound Point case or the OEP case, and even going back to Aries back in 2020, is you have cases where there was no underlying trading violation, but a conclusion that the controls were deficient. And it's that disconnect between the conclusion that a control is that controls are inadequate versus whether or not there was an actual underlying violation that those inadequate controls yielded. I think it's a hard argument to say, in the absence of a violation, your controls are subjectively or objectively deficient, that we believe that the absence of, and in these cases, the way that the division is looking at, particularly investment advisors, it seems to be less so with broker-dealers, but more in the advisor space, that the division is imposing these settlements on controls violations alone. And I think 15 years ago at the commission, if you came up to the commission and you only had a controls violation and you had no underlying trading violation, that would be a case that would be tough to get through. Because there's, in the absence of an actual trading violation, it raises the question, so what was deficient? If there hasn't been a violation, what's deficient? And it's really the staff saying, well, we don't think your controls are up to snuff, or we don't think that they're reasonably designed, taking into account the nature of your business. So my view is that, that when you look at these sweeps, that whether it's MNPI or off-channel comms or whether it be the compliance rule or whatever rule it is that they're sweeping, that those cases have risk to them now that didn't exist historically where there was no underlying violation.
It kind of begs the question of, it's almost a resource issue in terms of, identifying actual cases to bring. I'll throw this out to anybody on the panel. How do you all think the SEC will go about identifying actual substantive violations of insider trading with respect to this sector kind of?
So Bridget, what we haven't talked about is how the SEC's data analytics have enabled it to leap ahead of where it's been in terms of analyzing trading in particular securities. So they have the ability through the techniques that they use to, and this is one of the things that was when we started specialization back in 2009, 2010, one of the issues in insider trading was how to specialize in it. What is it that, what are the tools that we need to be able to do this better? And one of those tools was this Artemis program that we developed that enables you to look at sector trading very easily, very simply. They can organize, they can sort data in a way that enables them to see the same traders in front of the same securities, whether it's the security that is the subject of the news or whether it's the security that may move in tandem or in sympathy with that security. They have the ability technologically to identify that trading very easily. It's no longer the case that they have to hunt and peck through brokerage statements and then go blue sheet and then take the blue sheets and then go look and see who traded. It's much more automated and much more analytical now.
Dan, will that get magnified with the consolidated audit trail coming into place?
For sure. And the CAT basically will allow the Division of Enforcement to recreate a particular person's brokerage account statement. It effectively allows the regulators to gather enough information to show, to effectively reconstitute an account and see what's in it. And just by virtue of the day-to-day, day in and day out trading is available through the CAT. So yes, but the issue with the CAT is the SEC has, and it's a different subject entirely, we could spend a whole panel on it, but that the SEC did a really good job of requiring the industry to spend all this money and adopt this reporting requirement, this real-time, near real-time reporting requirement, but didn't really make the same level of investment in its own analytical capabilities to know what to do with that data once it gets to the front door of the SEC. So my old group, the Market Abuse Unit, was tasked with developing the framework in which trading cases would be investigated in new and novel ways. And one of those ways is was to anticipate, when we get the CAT, what kind of analytical abilities will that give us to identify suspicious trading?
So it'll basically look for market developments, then look for things parallel to it, and with other, and for this kind of shadow trading related stuff, look for other market movements that are sympathetic to it, I guess, in time and reaction volume, and then it'll look for anomalies in trading within those particular issuers, all within seconds, and within parameters spit it out for an analyst to take a look at.
Correct, and they become enforcement leads that then can be exploited.
Yeah.
Great. So in our last couple minutes, we're going to shift to another interesting topic in this area, which is the 10b5-1 plans. And I'm going to kick it to John to discuss with us. So we saw the interest out of the DOJ in this area. So I want to ask John to kind of give us some takeaways from that. But also, do you think that the shadow trading and this expanded scope of potential liability will filter into 10b5-1 plans? I mean, how do you see all that playing out?
Well, so just the recent case on the 10b5-1 plans, it was a criminal case against Pizer, who was former co-founder, executive chairman, and chairman of the board of OnTrack. In his role, he found out that there were real concerns that they were going to lose one of their big customers, Cigna. And he found out there was going to be a May 18th meeting where Cigna was going to give them some news as to whether they intended to continue or not. And so, unfortunately for him, he decided, well, now's the time to set up a 10b5-1 plan. And so he goes to the first broker to set up the plan, and the broker said, yeah, we can do this for you, but you're going to have a 30-day, we're going to require a 30-day waiting period. Well, this was early May when he's trying to set the plan up. The meeting is on the 18th. So he says, well, I think I'm going to use a different broker. He goes to a different broker. He sets up a 10b5-1 plan. That broker warns him, you really should do a 30-day cooling off period. He chooses not to follow that advice, and then chooses to blow through and sell a very large number of securities. The meeting on the 18th happens. He learns that Cigna has basically said, yeah, we're going to end in a year. Within the year, we're going to end. And his plan keeps on selling right along. And then he hears further information about, well, we've got another meeting set up with Cigna, and looks like we might have some trouble keeping them. He sets up yet another 10b5-1 plan and sells even more of it. And so all in, I think he sold about $12.5 million. And he was criminally prosecuted, of course, and convicted. And it's interesting because DOJ did say that they found the case through data analytics. And so, there's a tie-in with all of this in terms of data analytics and trying to find these cases. And the SEC has always been, we all know the SEC's always been hunting, and DOJ hunting for instances where 10b5-1 plans have been abused to commit insider trading. And so, we've seen sweeps, 10b5-1 sweeps, where they're trying to identify those instances. And so I do think that they will, continue to try to find instances where people are using 10b5-1 plans inappropriately. In this instance, the big takeaway is, look, if you have material non-public information, a 10b5-1 plan is not going to help you in the least. In fact, it might be very helpful evidence for DOJ to show that, you're trying to insulate what is otherwise an illegal scheme with a 10b5-1 plan.
Correct me if I'm wrong, but isn't it the case that that 30-day, the rule hadn't been put in place yet?
Correct.
But it was evidence of him appreciating the materiality of the information?
Yeah, so the new rule puts in place waiting periods, and that rule wasn't in place yet, but a lot of brokerage firms and a lot of regulatory attorneys in the industry were advising executives have a 30-day cooling off plan before your trading starts. It was it had been pretty well talked about within the industry that was a best practice. And the fact that he, basically chose to shop brokers because of that, because he was facing this looming deadline of May 18th, really was a bad fact for him.
Yeah, absolutely. Last question. Do you see, and anybody on the panel, but certainly John, see the use of 10b5-1 plans being expanded if this theory of sector liability continues, that officers and directors could protect themselves with an expanded plan?
You mean an expanded plan to sell stock in securities that aren't the securities of your company? That's an interesting question. I don't know. What do you think?
Within the sector.
I think policies are going to be expanded. The insider trading policies will be expanded to include those, whether 10b5-1 plans. I mean, I'm not sure that the way the 10b5-1 is written, that it would necessarily encompass those securities, but I don't see any reason why it couldn't.
Because part of 10b5-1 was really to deal with people that are associated with the company.
With the company,
that want
right.
to sell their shares. It's not.
Yeah.
It doesn't quite fit, but you could certainly see some bright person saying, "Hey, let's reform the regulations so that we get some protection for sales in sector-based companies."
Yeah.
I suppose.
Well, we'll leave it at that. Thank you so much.
Thank you, Bridget. Thank you to our Insider Trading 360 panel.